Hello, you're listening to the TerraLex podcast, where we break down current issues and trends in the legal industry. Join us as we gain valuable insights from our member law firms across the world, as well as from the in-house counsel community and experienced professionals in their field.
Welcome to today's TerraLex webinar on recent developments in global trade. My name is Nicole Rudner, and I work with the TerraLex practice groups and industry sector teams to drive client-focused collaboration with our members. Our speakers today are Alan Enslen, shareholder at Baker Donelson, Doreen Edelman, chair of the Global Trade and Policy Group at Lowenstein Sandler, Jonathan O'Hara, co-chair of the International Trade Team at McMillan, Sven Pohl, counsel with SKW Schwarz, and Alexandra Lopez-Casero, partner at Nixon Peabody. We will have some time for questions at the end of the presentation, and you can feel free to use the dashboard to submit those questions. With that, we're going to get started, and so I will turn it over to Alan.
Great, thank you, and welcome everyone. Good morning, good afternoon, or good evening, wherever you may be. We appreciate you joining us today. Okay, the topics I'm going to be covering today are the U.S. customs and import relief issues. We'll spend majority of our time talking about the current tariffs and the current investigations related to those, and we'll also do a brief defense trade update at the end. I'll tell you at the outset, the slides contain more information than we have time to cover, so the intent is for you to have a takeaway reference on some of these issues. If we do not cover an issue that you want to discuss, please don't hesitate to ask a question that we can address later in the broadcast. Okay, before diving into the better known tariff issues that we read about every day and experience every day, we thought it would be helpful to do a bit of an overview on U.S. import relief avenues that companies can use. First off, we shouldn't lose sight of the anti-dumping and countervailing duty laws. AD/CVD, I would argue, remains the primary route to substantive import relief for companies operating in the United States. If you're not familiar with AD/CVD, anti-dumping is essentially imports that are brought into the domestic market at less than fair value, or at least alleged to be. And countervailing duty cases deal with subsidization by the exporting country. So these are multi-phase investigations. Essentially, on one side, you have the U.S. Commerce Department, International Trade Administration, looking at issues of whether or not there is dumping or subsidization. And then somewhat parallel, you have the U.S. International Trade Commission looking at issues on material injury or threat of material injury. And this all then comes together in final determinations and possibly orders. The Commerce Department maintains roughly 500 active AD/CVD orders. As you can imagine, there has been a spike in this activity within the current administration, but frankly, in the last administration as well. So it's a very often used tool to keep in mind. And then also rarely talked about are the Section 201 investigations. And 201 is a safeguard action. It's designed to bring temporary relief to a domestic market when there's serious injury. That's the buzzword to note. The one thing to remember about a Section 201 action is that it does not require an unfair trade practice finding to go into effect. And for that reason, the injury determination usually is a bit more difficult. So these are very rare. There are two that are in place right now, as you see on the slide, regarding residential washing machines and solar cell technology. And these were the first ones put in place since 2001. Now moving on, and we're going to drill down more on the next two with other slides, but these two you'll be more familiar with as a broader audience. Section 232, which is rooted in the Trade Expansion Act of 1962, is a national security-based investigation and trade import relief, angle. The investigations are run by the Commerce Department, and there have been 14 232 investigations since 1980. 5 of them are in this administration. So the most recent one prior to this administration was also in 2001. So again, we're going to drill down more on 232. So I'll jump to the last major bullet there. Section 301 investigations under the U.S. system are conducted by the U.S. Trade Representative. USTR conducts the investigation. It's focused on allegations of unfair trade practices, just to put it generally. The one you're probably most familiar with, and that many of us are living every day, are the USTR's 301 investigation into China's alleged unfair trade practices and policies. And that was initiated in August of 2017, and as we all know, put into place and is the reason for the many lists of tariffs that we have for goods imported, Chinese origin goods imported into the U.S. Again, more on that as we progress. So to look a little bit more in detail at the Section 232 tariffs, the one that most people are familiar with are the first 2 actions within the Trump administration, and those were the investigations into steel and aluminum. And again, the focus of the investigation is toward national security concerns, national security threats. It resulted, as we all know, back in March of 2018 in the imposition of 25% tariffs on steel imports, 10% tariffs on aluminum imports, and those continue on today. So think of those as the first and second 232 actions within the Trump administration. There were temporary country-based exemptions for a number of U.S. trading allies. Most of those have gone away. But there are still countries receiving quota-based exemptions, as you see on the slide there, Australia and Argentina on the aluminum case, and then Australia, Argentina, Brazil, and South Korea on the steel case. These did result in retaliatory tariffs from a number of major trading partners, as you see on the slide there, excuse me, and as well as a number of WTO challenges that are still in varying stages of being worked on. And then you're probably aware that the U.S. understandably eliminated the 232 steel and aluminum tariffs on Mexico and Canada back in May of this year in deference to the ongoing USMCA negotiations. Now, there is a tariff exclusion process for Section 232. This was established, all under Commerce Department, but established by the ITA, which is coincidentally the same element within Commerce that administers the anti-dumping countervailing duty cases. But the exclusion process for 232 is administered by the Bureau of Industry and Security within Commerce, and BIS is the Commerce Department's primary export control regulator that regulates the dual use export control regime known as the Export Administration Regs. Now, we have a scorecard based on the first year of data from the 232 tariffs. On the steel side, the exclusion requests have about a 25% win rate. They haven't all been adjudicated, but for those that have been received decisions, we're at about 25%. A little bit better on the aluminum side, fewer in number, but 85% is the rough win rate on tariff exclusion requests. So there is hope for exclusion on for tariff exclusions on the 232 side is the short answer. Okay, the additional investigations, I mentioned there had been 5, and we just talked about the first 2. The third one is one that I suspect is key to many of us in this audience today, and that is the investigation on automobile and automobile parts that was initiated back in May of 2018. This one was Commerce initiated. It was not based on any request by U.S. firms. And we're going to, because of the importance of that, we have a separate slide on that. So I'll jump to the 4th and 5th 232 investigations just so that you're aware of them. There was one initiated in July of 2018 in response to a petition by 2 U.S. uranium mining firms into uranium ore. Commerce did find that these imports were threatening to impair national security, but President Trump did not concur with Commerce's determination. And so in July of this year, he established a nuclear fuel working group that owes a report actually middle of next month and is looking at issues for the U.S. nuclear fuel supply chain. And then the last one that was initiated, the most recent 232 investigation, is on titanium sponge imports. It was initiated back in the spring of this year in response to a petition by U.S. firms. If you're not familiar with titanium sponge, you don't want to clean dishes with it. It's a corrosion-resistant structural metal often used in military aircraft. And that report is expected out in a couple of months, in November of this year. But again, is the most recent 232 investigation being conducted in the U.S. So as I mentioned, to drill down on the third 232 investigation, the one into automobile and automobile parts, near and dear to many of us in this audience, I know, because of the ramifications, potential effects on cross-border trade. Automobiles, SUVs, vans, light trucks, and parts for all of the above are really included in this. And one of the points of significance, or the value of these imports into the U.S., is thought to be, or anticipated to be, greater than the steel and aluminum imports. And that's based on just the way that the automotive supply chains tend to be set up around the world. The final 232 report was submitted back in February to the White House, but as you probably all know, it was an affirmative finding. However, it has been delayed. The final determination or final decision by the president has been delayed, really in deference to ongoing trade agreements, particularly with Japan and the European Union. But the deadline is mid-November of this, coming up on us. So if the negotiations are not successful, we're going to be seeing tariffs in the 10 to 25% range, potentially on those products, and it will be, very significant. Okay, we're going to jump to the 301 investigation. This was initiated, and again, this 301 is focused on unfair trade practices. This is in particular USTR's investigation into the allegations of Chinese unfair trade practices. And I'm not going to drag you through all the wordy slides that you have in front of you. You can read it for yourself, but I will call your attention to two particular findings that came out of the 301 investigation, because they're significant to all of you who are, conducting business, globally. First of all, the first bullet, finding that China uses the joint venture requirements and foreign investment restrictions and other processes to pressure technology transfers for companies operating within China. And if you will, you can connect this to the ongoing emerging and foundational technology export controls mandated by the Export Control Reform Act of 2018 that are being rolled out really as we speak. You can see the direct connection as to why those are going into effect, because it's a partial cure, partial remedy to this finding. And then similarly, I'm going to point you to the third sub-bullet there, the finding that China is directing and facilitating a systematic investment and acquisition of U.S. companies in order to generate, technology transfer, from the U.S. You can connect this to the ongoing Foreign Investment Risk Review Modernization Act mandated changes to the CFIUS Foreign Direct Investment Review program that I know Doreen is about to tell you about. And so, again, you can see the connections within the quote-unquote broader trade war. You can see the connections between this 301 investigation and other events that are, occurring as we speak. So, in response, were born the 4 lists that we know. Okay, this is really a chronology, for time constraints. I'm not going to take you through all of this, but it's a helpful chronology to have, and it really highlights across the top line, the imposition of the respective list 1, list 2, and the initial 10% of list 3 tariffs. And then more updated, you can see the chronology of when the list 3 tariffs were set to rise from 10% to 25%, delayed a couple of times in deference to the ongoing trade negotiations. And then Once it did increase to 25%, we have the May 2019 proposal of List 4, which is essentially everything else coming into the U.S. from China, the $300 billion tranche, and then that List 4 again suspended based on ongoing negotiations. And that drives us toward the latest developments when in August we have List 4 tariffs going to 15%. Being bifurcated into two different tranches, one that's already underway earlier this month, and one that's going into effect in mid-December. Do your Christmas shopping early is the moral of that story. And then we have in mid-October, in a couple of weeks, we have lists 1 through 3 are scheduled to go from 25% to 30% on the increase. We do have a tariff exclusion process, as you probably know, for 301, and for time constraints here, I want to be respectful of the other presenters' time, so I need to just have you glance at this, and I'll highlight the fact that these exclusion requests really are based on arguments of non-availability, domestic and third country, and really showing your work as to what efforts you have done to try to make those determinations, as well as economic harm arguments, which are obviously unique to every situation, and not just to the company, though, but in particular to how it's affecting local communities. That's what we're seeing as being more successful in terms of getting tariff exclusions. And then any kind of connection to Made in China 2025 or similar types of technology-laden programs. And I would say the moral of that is the closer you are to a critical technology, in the FIRRMA context, the closer, more problematic your argument's going to be under the Made in China 2025 program. Quickly, our tariff exclusion scorecard this is, again, as of the end of last month, the List 1 has about a 30% win rate. List 2 has roughly a 19% win rate. And again, these are not final. Not every exclusion request has been decided upon, but for those that have, these are the rough rates. And then, as you probably know, List 3 is still underway for an exclusion process that closes out on upcoming Monday night on the 30th of September. And in addition, if you're not up on the latest and you're looking for any tariff exclusions, there was quite a few that were released last week in the Federal Register for Lists 1, 2, and 3. On the List 4, I've already mentioned this is a bifurcated, way that this is being rolled out, obviously tied to ongoing negotiations, but that gives you a little bit more idea of how that, what that's going to affect. And then the exclusion process hasn't been announced yet, but it, undoubtedly will be, and will probably be frighteningly similar to the one that's rolled out for List 3. USTR is learning as they go and are incorporating things to try to make the process more efficient. Okay, in terms of tariff mitigation, and again, I apologize for having to run through this so quickly, but I want to emphasize just a few key points. If you're looking at some kind of tariff exclusion option, the first thing to do is to confirm your HTS classifications and make sure you actually have the right ones, or your clients are working with the correct ones. And then, consider all of the duties and the impacts. Role of customs broker and freight forwarder is in there just to remind companies that as the importer of record, they are responsible for making sure this information is correct, even if they're getting assistance in doing that. And then, as I mentioned a minute ago, really assessing the merits of whether or not a party has good arguments. First of all, looking if there's a like product submission under the 301 regime. You can take advantage of someone else's exclusion if you fit within the scope of that exclusion. So that's a handy route to go to. And then in terms of alternative strategies, we all have heard a lot of talk about different bases for doing this, particularly third country manufacturing, which works for some companies, doesn't work for others. HTS heading shift is not going to help many people once everything is in play after List 4, so that's becoming less important. And the final thing I'll point out is on country of origin change, everyone should note that country of origin standards really are not harmonized in the same way that valuation and classification standards are between countries. So you have to look very carefully at what the standards are that you have to meet. And I think there's a good bit of misunderstanding out there about that. Okay, and then quickly on export defense trade update, really not a lot has happened within the ITAR over this past year. We are still waiting on final rules for the last three categories of the U.S. munitions list that was scrubbed during export control reform. These are the guns and ammo categories, and it is still on track. It's just to be determined as to when it's released. Will result in a number of items moving over to the Commerce Control List, although still heavily controlled for export there. And the things that should remain on the U.S. munitions list largely is going to. So, and finally, these are the ITAR amendments that have been put in place. Maximum civil penalty has got its usual yearly bump, so a bit more expensive, but probably more important, the exemption, the buyer for exemption has been expanded a bit to further the ease of U.S. companies to participate in the conventional arms transfer policy objectives. And then you're seeing most recently a number of radars removed from the USML Cat 11, really to benefit the autonomous vehicle industry and related developments there. So you're seeing a continual tension with this need to control emerging technologies, but yet not to control them in a way that prohibits their actual dual civil and military use. So with that, I will turn this over to my colleague Doreen Edelman.
Thanks, Alan. That was I appreciated that run through of all the updates in 15 minutes or less. I'm going to jump right into CFIUS. I know everyone has a different degree of knowledge on CFIUS, but I'm going to start with the basics because there's no other way to do it. CFIUS does sound like a disease, and I suppose to some companies it may feel like a disease. Last week, 300 pages of regulations just came out, which I will talk about in a moment. But for now, this is the basics of how CFIUS works because the new regulations are still in a comment period. There's 1 month of that. So CFIUS is an interagency committee. It is managed, if you will, by the Department of Treasury, but all the different acronyms in the federal government have either a seat at the table or a seat in the row behind the table and can weigh in on particular transactions that may affect their area of expertise. The point of the committee is to review and approve foreign direct investment that affect our national security. And what we're seeing is a shift in how national security is reviewed. 20 years ago, national security was definable as defense military. And now it obviously can be almost anything. The Grindr app is a good example. It was going to be purchased by a Chinese company. The Grindr app is a dating app, and it collects personal data. It includes health information on HIV, and for that reason alone, the transaction could not go forward as initially intended by the parties. So national security has become everything from logistics to food to data to most manufacturing industries requiring review. Some of the changes that we're seeing in this ongoing review process, which began in the end of 2018, just incorporated the prior practice, the way the procedures and reviews were taking place at the Treasury Department, but others are new and still in the process of being defined. Everything is supposed to be finalized by March 2020. And right now we're in the process of having a lot of these provisions defined and further interpreted. Okay, so if you've got a client or if you are a company thinking about foreign investment, you should be aware that you've got to begin, no matter how big or how small you are, by knowing certain fact patterns. You must know not just the industry that the target company does work in, but the industries that their work may touch. And that's relevant because they may be in a testing business, but that testing can involve products in certain industries that are part of the pilot program that requires a mandatory filing. You need to know where all the businesses have facilities, because there is a real estate piece to this. And if the facilities happen to be within close proximity, which is now looks like going to be defined as a mile, which is pretty close, but to a military installation, that can also be a factor. You have to have the ownership structure of the buyer. And I know in a lot of these transactions, that is not something that is clear at the beginning of a transaction. And based on the negotiations between the parties, new holding companies can be set up, offshore entities can be set up, and that continually moving ownership structure has to be reviewed by both sides to understand the CFIUS implications. And there has to be full disclosure. When you file these filings, you have to provide charts that show the ownership structure down to the beneficial owners, because remember, that's the point of this, to see who will have ultimate control or a non-controlling interest that the government cares about. So trusts, public companies, to some degree, you have to peel back all the layers of the onion and get to the actual individual owners, or if they're publicly traded company, down to 5%. And then you've got to understand the degree to which the buyer is going to be involved in the new business. Are they going to be a limited partner and only have access to financial data? That's a completely different story, and there's an exception for that. Then if the foreign party is going to have day-to-day management or be involved and have access or control to any type of the technology, the data, or the infrastructure. And that talks about post-closing rights, et cetera. And what you've got to think about what's going to happen in the future. If there are options, if there's more equity to be purchased. I mean, it's a full review, a 360 of the scope of the transaction. Next slide, please. Okay, so when is a filing mandatory? A filing, there's two ways you have to look at this. There's a U.S. piece of when it's mandatory, and there is a foreign buyer's piece. From the U.S. side, if the U.S. business is involved in the production, design, testing, manufacturing, fabrication, or development of what is defined as critical technology, and in one of the 27 pilot program industries. So that's the test on the U.S. side. And the foreign person will have either control or a non-controlling interest and access to material non-public technical information, or if they'll have board rights, advisory seat rights, the rights to nominate someone to the board or to an advisory role, or if the buyer will have involvement in the decision-making regarding the use, development, acquisition, or release of critical technology. I know that is a huge mouthful and needs to be broken down, so we will go through some of it to the extent we have time. The pilot program industries. The 27 pilot program industries are basically manufacturing. There are a couple of non-manufacturing where we talk about nanotechnology, biotech, aluminum smelting, search and detection for aeronautical and instrument products. But for the most part, they have to do with battery manufacturing, telephone apparatus manufacturing, turbine, aircraft, engines, ball and roller, computer storage, guided missiles. You get the picture. But remember, when we ask for the NAICS codes of the target business, just because their code may not be in one of these pilot program industries, you've got to think about whether that business touches these pilot program industries. We had an interesting experience this morning with a filing. The committee, we had two NAICS codes listed for each party, the buyer and the seller, and the committee asked us to pick one. And it's interesting because the U.S. company chose the most applicable NAICS code, which is not in the pilot program industry. So it's just interesting dynamics as you go through these process. Next slide, please. Okay, the voluntary program. And I would argue that if you are in a mandatory filing situation, you often may choose to make the voluntary filing instead, because the voluntary filing will get you to the safe harbor, which is the point of this whole process. You make these filings so that the government will not unwind or require asset sales or some other type of mitigation of your transaction because it believes there's a national security concern. And if you make the mandatory filing, which is called a declaration, there's three options. The government can either tell you that there's no problem, they can tell you we can't do it in the time allotted under the mandatory program and we need you to file a voluntary filing. So then you've already lost a 30-day at least period. Or their third option is they can shrug their shoulders and they can say we didn't have enough or have enough time to rule and we don't have an opinion. So one way to look at that is, well, if they cared enough, they would have told us to make a voluntary filing. But if you have a company or parties that are very risk averse and you get a shrug, you're no better off than if you hadn't made that declaration or notice filing. So again, the parties may choose to go ahead and make this voluntary filing. And this is the traditional CFIUS filing that has been around a long time. Any deal that could result in control of a U.S. business by a foreign person, or any increase in the rights of a foreign person of a U.S. business that could result in control, or real estate investments, and then some non-controlling investments in critical infrastructure and sensitive personal data. And then, of course, there's the catch-all, any transaction that's designed to evade or circumvent CFIUS review. Critical infrastructure and sensitive personal data have just been defined in these new regulations that came out last week. There's a lot of information they're providing about them. I'll mention them in a minute, but it's very important if you're concerned about this, that you take a look at the Treasury right on their homepage. They've issued two documents. The regulations, they've broken them down into Part 800, the general terms, and then the real estate terms. And critical infrastructure and sensitive personal data are in the first set, and they give a lot of information to the point they actually give you the functions involved in critical infrastructure that they now say are concerns of the committee. Okay, so the key here to that mandatory determination, you have to know what is critical technology. In some cases, it's relatively easy. If you have a company that does a lot of import and export work, if they already have export classifications for their products, either on the USML or on the CCL, then you know that they're critical technology. If they have anything to do with nuclear materials, selected agents and toxins, or if they are emerging in foundational technologies. And this piece has not been fully defined. The Commerce Department, as Alan said, is working on expanding what it controls under the CCL, and it is providing definitions for emerging and foundational technologies. We are anticipating that things like biotech, artificial intelligence, advanced computing, robotics, advanced materials are all going to roll up into these emerging and foundational technologies. So that's wide open and that's difficult. I'm also finding that companies, particularly if they're startups, or if they don't export and they haven't done work around the world, they don't have their classifications. So you don't know if their items actually are on the ITAR or on the CCL. And that is a big problem, particularly for a company, say, that tests chemicals, and they're working literally with hundreds of chemicals. So to determine whether critical technology is involved in what they're doing is not a quick phone call to determine that. So it takes some time and effort in working through these different definitions. Okay, so what do you do at this time? The goal here is to provide a safe harbor or to provide a legal memo for a company to let them know whether they need to make this filing. So what I think the role as lawyers, for the lawyers on the call, is to determine whether a mandatory filing is needed. Then when it comes to whether a voluntary filing is needed, that really goes to the risk tolerance of the parties and the value of the deal and their financial, if they're in bankruptcy and they really can't put any more money into this is a factor. If it's a huge deal, if it's worth several $billion, most buyers will want to go ahead and make a voluntary filing, particularly if you're not quite sure if it's needed or not, and you want to get that safe harbor. So there are a lot of different factors that go into making a decision. Timing is also a big deal. The timing has changed since November of 2018 when the new law and regulations came out. They have given the government more time, but it is on a strict timeline. Do you want to go to the next slide? You'll see here that on the mandatory filing, the committee has 30 days, but you have to file 45 days before. And realistically, it definitely takes at least a week, if not longer, if you're dealing with overseas offices to get it together. And there is a practice in the committee where you pre-file. Companies actually file in advance. We just did a pre-file, and the government took 2 weeks to get back to us, and that pre-file is done before the clock starts running. It actually buys the government time to make suggestions and comments of what they want to see in the materials, so that when you make the filing and the clock starts running, they're not losing as much time and they can get through. So timing is a big factor depending on your deal time. Cost is also a factor because it takes a lot longer to gather all this personal information you need on the foreign owners, everything from CVs for beneficial owners to ID numbers, passports, all the basic information on the individual. Same thing on the voluntary process, but it's actually an even longer process, 45 days. Then it can go for a second 45 days, and then it can go up to the president, so that normally does not happen. The voluntary process is more of a balancing act of all the different factors, and it's longer when it's filed, and usually takes more time to put together. Okay, so here's where we are today. The new regs came out last Thursday. The comment period, they gave exactly 30 days, so October 17th. There's going to be a hearing. I think it's tomorrow. No, it's Friday. I think it was released yesterday. The Treasury Department said they will do hearings East Coast time U.S. starting at 10 a.m. for about an hour and a half to answer questions and run through the regulations. They usually don't provide additional information in these open events, but you never know. Sometimes you can get a gleam, or through the questions you can learn something. The regs will be implemented no later than February 13th, 2020, when all of the FIRRMA, the 2018 law regs will come in. As I said, you've got two sets here. They're replacing Part 800. So you really, if you're doing a filing next month or the following month, you can hedge your bets and not factor in these new definitions, but I don't think that's productive, because the bottom line here is if the government thinks there's a national security problem with a transaction, unless they've given a safe harbor, they can unwind that transaction in the future. So it behooves all of us to learn the new definitions and use them in our filings. One happy piece of news is that many individuals, companies have hoped that certain countries would get exempted out of this process, sort of our best friends. And rumor has it that there are no names in these regulations that just came out on the 17th, but rumor has it that it will include Australia, New Zealand, UK, and Canada. But as I said, nothing is in writing yet. The definitions of critical infrastructure and sensitive personal data are very helpful. The real estate transactions, this is also very helpful because they define exactly what the concerns are with the real estate transactions. They define the limits with the mile around military installations. They clarified what we already mentioned about limited partners. If they purely are going to have access to financial data, there is an out for pure limited partner investments. And they add an optional short form for voluntary filings as well, if the parties are willing to take the risk that they're going to get an answer and be satisfied with that answer. So I'm going to stop there and pass it on. And questions are certainly invited to any of us if there isn't time in today's program.
Thanks, Doreen. So it's Jonathan O'Hara here. I'm the co-chair of the International Trade Group here at McMillan, and we're a Canadian law firm, so I'm going to give a bit of a Canadian perspective. Can we flip to the next slide, please? So here are the 5 topics that I'm going to be talking about relatively quickly. So the first, USMCA, where that stands with Canada. The second, there are some pretty significant Canada-China trade issues going on now, which are somewhat in the shadow of the U.S.-China trade war, but potentially still of interest. The third is the impact of the U.S. lifting the 232 duties that Alan talked about earlier, and Canada removing retaliatory duties. So that's been important for a lot of businesses in Canada. The fourth is the somewhat recent conclusion of the Canadian safeguard proceeding. That happened in April, but still might be worth an update. And the fifth point is some increases, in Canadian export controls, because Canada has been has now joined the Arms Trade Treaty. So we'll jump in, if we could flip to the next slide. So in Canada, the USMCA is not a terribly contentious topic. Canada has an election, a federal election, that will be happening in less than a month's time, but both of the leading parties are generally on board with the USMCA. I mean, it's the USMCA legislation passed some of the initial steps in Canada, but because there's an election, that will kind of all go away and have to be redone once the new government is constituted after the election. That new government in Canada, it's not entirely clear what that's going to be. It could be the current Trudeau government gets a majority after the election. It might be some kind of coalition government potentially between the current Trudeau Liberals and maybe the New Democrats. It could be the Conservatives get a government that's either a majority or they are able to form some kind of coalition government. So we'll see what happens with the government perspective, but the impact on the USMCA is likely to be relatively minimal. It's likely to move forward regardless of what government takes power. However, the Canadian position so far has been that we're going to kind of wait and move in tandem with the U.S. So I think there is maybe a little more contentiousness going on in the U.S. Congress with respect to the USMCA, and so Canada is kind of waiting to see how that plays out. Unlike Mexico, I think, which has started to already take steps to implement the USMCA, Canada has not been that proactive. So we're mostly waiting to see how things unfold in the U.S. So Canada trade relations, certainly the state of Canada-China trade relations is probably better than the current state of U.S.-China trade relations, but for Canada, it's been a very difficult situation, and it all arises from Canada's arrest of the Huawei CFO when she was in Vancouver. So I know Alexandra is going to talk more about the Huawei situation, but just for Canada arrested the Huawei CFO based on an extradition treaty it had with the U.S. The U.S. provided an extradition request supporting documentation, And so the very fact that Canada arrested the Huawei CFO and is now going through an extradition hearing to see if there's adequate documentation to hand the Huawei CFO over to the US, that has caused Canada some enormous international trade pain. So China, I'm going to say, retaliated in respect of that arrest in a few ways. I don't know that China has definitely confirmed that all of these actions are in response to the Huawei CFO's arrest, but it certainly looks like that. So China arrested a couple Canadian, notable Canadians, a former diplomat and a businessman who were in China kind of days after the Huawei CFO was arrested. The Canadians have been arrested on the allegations of conspiring to steal state secrets. In terms of actual trade actions, China has largely stopped importing canola seeds to China, which was a very significant industry for Canada. I mean, billions of dollars of Canadian canola seeds were going over to China. On the slide here, you can see the third last bullet. Canola exports to China were roughly 10% of all of Canada's exports to China. So China closing the door on that has been very significant. There have been increased inspections for pests, for quarantine concerns, for contaminated food ingredients, all those kind of things that are kind of those non-tariff trade barriers, which seem a little bit discretionary. Those have all increased as against Canadian goods. So I just talked about canola and further on these exports that have been subject to, I'll say, maybe greater Chinese rigor to the point where Canadian exports have, significantly diminished. That includes a lot of other Canadian agricultural products: pork, beef, soybeans, peas. All these have been impacted. In fairness to the Chinese authorities, part of their increased diligence uncovered some falsified health certificates, which then kind of complicates the situation, particularly from Canada's perspective. No longer can Canada say, well, this is all clearly just in relation to our arrest of the Huawei CFO. No, there have been some falsified health certificates that have been found, and that has led to all kinds of suspensions. And so now the situation is even more complicated for Canada to resolve. So in terms of resolution, the Huawei CFO's extradition hearing is expected to end in October 2020, so more than a year away from now. We will see how that all unfolds and what happens with Canada trade relations between now and when the extradition hearing concludes. This has to do with the 232 steel and aluminum tariffs that were lifted as against Canada. Alan talked a little bit about that earlier. And Alan's right that certainly happened in the context of the USMCA negotiations, but it was interesting that there was a bilateral agreement, a short bilateral agreement, signed between the US and Canada that kind of led to the actual lifting. The US signed a very similar, if not almost identical, agreement with Mexico at the same time for the lifting. The agreement is quite short. I mean, it fits on basically a page, depending on the font you want, and it has some fairly unclear commitments between the parties to kind of combat unfair trade, prevent transshipment of aluminum and steel. It has some provisions regarding surges of steel coming from Canada or coming from the U.S. and how that could lead to renewed tariffs. But I mean, I think the general consensus is along the lines of what Alan said. This was all done in the context of trying to further the USMCA, because the USMCA had been signed and agreed to, and this kind of vague bilateral agreement doesn't actually give or commit anybody to anything too much, which still leaves open some uncertainty as to whether steel tariffs are going to come back against Canada based on some of the vague and potentially different interpretations of what that bilateral agreement entails. The steel safeguard. So again, referring back to Alan, he talked about a Section 201 proceeding in the U.S. In Canada, we call it a safeguard proceeding. They are extremely rare in Canada. In this case, it was very exceptional because the government, for the first time ever, said that they saw critical circumstances requiring them to kind of make to offer provisional relief before a full investigation had happened. And despite the government saying that, there was these exceptional circumstances that justified exceptional measures, when the International Trade Tribunal ruled on it, and they're the investigating authority that has to inquire into it, the Trade Tribunal said, no, we don't see a justification for safeguards on 5 of the 7 different steel products at issue. So you certainly had a very different perspective from the government to the investigating authority as to what happened there. And so steel safeguards have largely been lifted. They remain on 2 products, steel plate and stainless steel wire. And the form of that safeguard is a tariff rate quota. So there's a certain amount even of steel plate that could come in from all countries without any extra duty, but it's only if imports go above that quota that's been set, then they will be subject to some additional duties. And I mean, I think off the top of my head, the duty rates are in the high teens or something like that. So it's significant. I realize my time is short here, and I want to make sure that Sven and Alexandra have enough time to talk. So I will just skip over to the next slide, to slide number the slide talking about about the export controls. So Canada has only recently become a party to the International Arms Trade Treaty, and to become a party, it had to tighten up some of its export controls relating to weapons. And so that has happened in 2 ways. The first way is the way that I talked about on this slide, that Canada has now taken jurisdiction effectively over the actions of its Canadians abroad. Any Canadian citizens anywhere are now prohibited from brokering transactions relating to weapons. So Canada's former controls were, we will not export weapons or technical data or anything related to these controlled goods from Canada. Canada has now gone further and put in place controls relating to brokering these. And so just the very act of facilitating these transactions by any Canadian citizen anywhere is something that will be caught by Canadian law. And anyone in Canada who is facilitating these kind of transactions will also be caught by these increased controls. Perfect. So this is my last slide, and the second way that Canada has increased its export controls is formerly the granting of export permits. Formerly, the granting of export permits was almost completely discretionary to the government. There were no kind of legislative guidelines, and there now are. Canada has put in place a bunch of considerations that must be taken into force, including relating to peace and security, to international human rights. And a lot of that came from concerns that the Canadian citizens had about large arms deals where Canada was supplying to Saudi Arabia, and some of the concerns around the Saudi Arabian regime. And there was no kind of legislative framework that required consideration of where those weapons might be going and what they might be used to do. And so now there are. So that's the end of my presentation. Thank you very much all for your patience.
Yeah. Yes, hello everybody. My name is Sven Pohl. I'm very pleased to speak a little bit about the European side. So we make now the big step across the ocean and see what happened in the last months in Europe. Please proceed to the next slide. Well, one thing I want to talk about is one decision of the European Court of Justice. I think it's quite interesting because it combines customs law with data privacy aspects. To give you a quick overview, what happened with the new Union Customs Code, the requirements for the authorized economic operator have changed. The authorized economic operator, and the shortcut is AEO, of course, is a little bit similar to the CTPAT permit or authorization, just it covers import and export. So in other words, it's some status a company can acquire if they are very reliable in the means of customs, importing and exporting. And with this new regulation in place, it said that not only the company itself has to be reviewed, but also the management and the relevant staff have to be reliable. That means they should not have committed any crimes or offenses against tax or customs law, which are considered severe. And in this respect, in Germany, the authorities thought a great idea to check that for the staff, for the employees, is they should give us their personal tax ID, and then we go to the finance department or to the financial authorities and ask them to check if they did any kind of tax fraud or whatever. This sounds quite practical from a German approach, but of course a lot of employees, and especially the management, were not happy about providing private data to the customs authorities to check on their private happenings. And in this respect, there was some lawsuit ongoing, which ended up at an ECJ decision, where the court decided or ruled out that in general, and that's the first thing, it is okay and does not violate data privacy law if persons have to give up the personal ID numbers or the personal tax aspects to the company and to the authorities to check if they are considered reliable, so the company can be checked if the company could be considered reliable. But, and that's the second point, they limited it to the managing director and to the ones who are really in the customs department, like the head of customs or the head of export control or something like that. So what they rejected was a German customs approach that everybody in a managing position, also maybe head of sales or head of, I don't know, logistics or head of finance or legal head, whatever, has to hand that over. This is not required. Also, not the further board of the company has to be handing out their personal ID numbers. Only really the core employees who are really doing the customs work and are in charge for that. And well, that was, at least in Germany, a big issue, because in the meanwhile all IAO authorizations were, I wouldn't say suspended, but they could not be renewed because customs did not know how to check and what they should do. And this also shows a little bit the different approach throughout Europe, because we are one union, but we are not one country. Like other member states were a little bit more practical. They just said, yeah, please confirm that you didn't do anything, and then I'm happy. I don't want to recheck it right now. We might just check it deeper if there are any incidents happening or we have any suspicion gained. A few other customs topics over the last 12 months is, of course, the new Union Customs Code replaces the old Community Customs Code. Sounds quite similar, is similar but not identical. It's like a complete new set of rules, and the UCC, Union Customs Code, entered into force already 2016, but we had a 3 years transition period, which ended this May. That means one thing is we needed new permits, a new customs authorization. If you had anything like, for example, for a customs bonded warehouse, you need a new one based on the new regulations. For the AEO, I just explained that earlier, you need a new one, which has to be issued by customs based on the new requirements and conditions and so on. So that was, of course, in the last month, let's say, time consuming, especially for companies and customs. The second thing is, in this new UCC, is the definition of exporter of record, which was quite heavily discussed, especially in some countries. Some countries take more practical approach in Europe. Some member states and say, oh, I don't care. Somebody's entered into the declaration. It sounds reasonable. I'm happy. And then you have countries like Germany who are very theoretical and say, no, but it has to be that person. If it's not the right one, we will fine him. So it might be quite important to have the right one, and the definition was in the first set of the UCC had some gaps. So you could have some business cases where it was not clear who becomes exporter of record. So, and that has been more or less, let's say, my personal view, closed now. And the huge issue was the security requirement. Let me explain that very, very quickly. With the UCC, they placed up basically the rule that for every customs authorization, you need to provide security in case at the end the customs duties are not paid properly. And one thing changed, and if goods enter the EU, the territory, they're normally placed into temporary storage. This can be for minutes, hours, days, weeks, but they're first in this temporary storage. And in the old Community Customs Code, that was just some custom status without further requirements, simply said. In the new one, this is some kind of authorization, and therefore the person needs an authorization for it, and to get that, you need to provide security for the potential customs duties. Sounds not so problematic, but it was a really big issue for logistical companies, especially harbors or airports, because they have so many goods going through that procedure that the values are getting tremendously high. I'm not quite sure. I think it was a mid-sized harbor in the UK who calculated that they had to pay, I lost the security of 42 billion euros or something, or pounds, and they had said, our company value is maybe a few billion, not 40 billion. So just because of the amount of goods, even though the real risk is of course so much lower, and therefore, let's say the associations were quite active in the last months before the transition period ended, and they got it done. There were some adjustments regarding the requirements. So basically, such companies can now ask for full relief of the security to be placed, and in that case, of course, let's say it with other words, it works as it did before. On the second point, the US-EU trade conflict is still active, but more on the political side, less on the legal side, because there are no new duties since the first rounds of extra duties on US products. It's just that the US president in the EU sometimes had some words about we will impose new duties, and then they say go back on the table and discuss it again. So there are no legal changes yet, and I think for the companies that's quite good. Nobody wants extra duties on cars or other products which are quite important for the international trade. And the last thing from the customs side, of course, which really kept the EU busy is the Brexit, or not to be the Brexit, or whatever the Brexit will be, because nobody really knows what's going on and what's happening with the UK. But it really takes a lot of resources of the EU. So there are a lot of reports about potential scenarios and what that means also for customs and importing and exporting purposes, and how much additional officers are needed just to handle the EU-UK customs procedures. If this will become true, that you have to file customs for customs declarations if you want to exit to the UK, or importing from the UK if it's no longer a single market as it is right now. And I think that is something which also took a lot of effort, but we don't have any law yet, because still, I mean, the UK has not really decided if they're going to leave or not, and when they're going to leave, and how they're going to leave, and if they want to accept the so far discussed agreements with the EU about how it works afterwards. So this is still a very hot topic. Well, if we took a look to the sanction side, to the export control side, I said no major breakthrough. Of course, there might be companies in certain areas who would say, oh, there was some change, which is quite important for me. But if you take a wider scope for a webinar like that, where we have 15 minutes, I think there is not much going on right now. Also from the legal side, there's a lot of political issues, like, for example, Iran. And we still have this blocking statute in place, which forbids European companies to comply with the US sanctions against Iran. And honestly, it is not working, because nearly all European companies comply with US sanctions. They don't do Iran business. And if they did it in the old days, they stopped it. That also led to the first case where I heard of an investigation, because this blocking statute should have been violated. There's one Iran company. Those accounts have been cancelled by the bank, because the bank said, sorry, we can't do that. We have some US annex, and therefore this is more important. Sorry, but your accounts have been cancelled. And that company filed a complaint at the district attorney against the bank. Unfortunately, in Germany at least, such investigation procedures are not made publicly available, so we don't know right now what the outcome is. I really looked through the sources but couldn't find anything yet. But at least maybe there's one case where a company might be fined for it. But frankly spoken, also for Europe, I think also for Europe, the Iran business is no longer active. The second point is, I thought actually when we planned this webinar, there will be some legal changes, because even though Europe really wanted to stick to the nuclear deal and tried a lot, let's say Iran is doing taking action which are also not seen positively in the EU, like the UK tankers which were blocked, or now the attack on the Saudi Arabian side. So I actually thought there might be some sanctions coming up, but so far they haven't done it. But I definitely would say the tensions are increasing in Europe. We had the Prime Minister from the UK, Mr. Johnson, said we need a new deal, more or less based on the US perspective. So I would say if nothing changed dramatically in the behavior of Iran, if he goes on this provoking way, there will be some kind of sanctions coming up within the next 12 months. If we have a look to Russia, the sanctions which are placed due to the annexation of Crimea are still in place. They are renewed every year, so I would say not much changing. There are, of course, minor changes. You have sometimes people on the list, or persons on the list, on the United Persons list of that sanctions, which are added or removed, but as I said, I consider this rather a minor change. Another issue on the sanction side, the EU really wants to make a reformation of the EC dual-use regulation. That is the regulation which covers the export of dual-use goods, but I haven't seen any progress in the last month. It's a little bit silent after this big first draft they issued, I think now 2 years ago already. A lot of ideas how to make trade easier, like new global authorizations, but also make it more difficult because we want to place new catch-all clauses, maybe considering human rights, things like that in this import exporting authorization regimes as well. So let's see what's going on there. And the last point, which is I think quite important for European companies, is the EU Commission issued some recommendations on internal compliance programs for dual-use goods, or the trade of dual-use controlled goods. So that is something, I would say companies should take a closer look, because that outlines the requirements or the expectation of the EU, how a company should be set up to be properly organized if they're handling dual-use goods. So I just placed also the link where you can just open the document. Well done. Of course, we could also talk, and I didn't do that, about the free trade agreements with Canada and Japan, which are in place and which are working more or less. Officially, they're working. Japan is quite difficult from the calculation of the origin, but I think that is too much for this quick wrap-up of changes. So from my part, I'm done. Thank you very much for listening.
Thank you, Sven. So Europe, I'm bringing us back to the United States. Alan spoke about defense controls in terms of export controls, and I will focus on two topics in terms of sanctions. First topic, the Huawei sanctions, and they will also talk about the concept of someone being subject to the EAR. We talk about what that means, because it's a very practical question. And then we'll also take a look at the latest OFAC penalty cases, because that's always very instructive for anyone having to do business, with the U.S. nexus. In terms of Huawei, as it's been in the news for quite a while now, Huawei was added to the U.S. entity list back in May, in addition to a number of its affiliates, and that is a big issue. We discuss what that means in a moment. It's a very broad prohibition. The day afterwards, the Commerce Department also issued a temporary general license, which, at least in our practice, we seem to be, it's quite limited. Not many companies are able to actually use it. It's, for example, for telecommunications service providers who export items that are necessary to continue the operation of existing networks, and only if there were existing agreements in place back in May when Huawei was initially blacklisted. That temporary general license expired August 19th, and the same day it was extended until November 18th. And there are some clarifications there. No surprises, really. Just clarifying again that the scope is very limited. For example, you can't export general purpose equipment to Huawei. There's also an advisory opinion that BIS published, and in addition to that, on August 21, the Bureau of Industry and Security, BIS, also added 48 more Huawei-affiliated companies to the entity list. So what does this mean? Here's an excerpt from the entity list, and this is the prohibition. This is just for one of the Huawei entities, the parent entity, that's the same for all the others. So the prohibition applies to all items that are subject to the EAR. That's a key term in export controls, and we talk about what that means. And there's a presumption of denial, meaning if I want to send a paper cup out of the US to Huawei, I would have to apply for a license, and if then put on a different hat, I put in my BIS officer hat at the Department of Commerce, I would have to deny that license, essentially. There's a presumption of denial for any licenses, so it's a very tight control. And the key question is really from a practical perspective, and not just for Huawei. So for folks listening here, it's not just a Huawei question, but is my item actually subject to the EAR? So I work, on that particular question at least every other day, because if my item is not subject to the EAR, these prohibitions, these broad prohibitions, simply don't apply. And what that essentially means is my item that I'm exporting from the US, from outside the US, is subject to the US regulations, put simply. And there are different rules. So it's very simple, right? With my paper cup going to Huawei, if it comes from the US, that's it. That basically ends my analysis. It is subject to the EAR because it comes from the US. If a Chinese paper cup coming to the US becomes subject to the US, to the EAR as soon as it touches the US. Same thing there. And then it becomes more interesting. As many of you know, the US has a de minimis rules. If I have a foreign item, foreign equipment or software that will be exported, re-exported to Huawei or to anyone else, and the question is this subject to the EAR? It's an it depends answer. We'll take a look at that in a moment. There's certain thresholds that apply. And if we reach those thresholds, then that foreign item, for example, coming out of China or out of Germany, will be subject to the EAR and the US laws apply. And then it's basically apples and apples and oranges and oranges. If we have software, the question is, do we have any software here that's coming out of the US that will be commingled? Again, there is a de minimis percentage. If we have technology that's foreign, again, for example, coming from China, just across the road from Huawei, or to anyone else. So the question is this subject to the EAR? Question would be, has it been commingled with controlled US origin technology? Again, apples and apples and oranges and oranges. Sometimes there's some confusion if I have a foreign-made item, right? For example, in Shenzhen, China, which is actually based on US technology, right? So not apples and apples, but I have a widget, a software that is based on technology, meaning technical data, right? Engineering drawings on the terms of software source code. We don't use that de minimis threshold in terms of value. We use a different rule called the direct product rule. The good news there is that it's actually quite narrow in terms of the application. And we could spend a lot of time talking about that. But for anyone who knows about US export controls, it's basically double national security controls. The technology has to be strictly controlled under an S, and then the product itself too, if it came out of the US. So again, I've got my foreign widget, right, that is being made, for example, in Shenzhen or in the UK or Canada. And the question is, okay, what came from the US, right? Hardware, software, or technology. On the different thresholds, as I mentioned earlier, there is 0 for some items, so that everything matters. There's also 10% for items that are going to embargo destinations, such as Iran. And if a Huawei, China would be 25%. So what does that mean from a practical perspective? I have to take inventory, right? If I am the company in Shenzhen, regardless of whether or not I'm US owned or in the UK or in Germany, I have to know what is in my item. And so this is just an excerpt redacted, but you would have to run a list parts and components to see in the green. Here we actually have quite a high number in terms of the context. So here we want to go further and find out, okay, this coil, for example, to the cable assembly, asking the Chinese manufacturer there, well, how does that look like? What does that actually contain? So it can go on, and we typically take a practical approach here and how deeper you go into the analysis. But this is really important. We're seeing BIS, the FBI, and others really drilling in on those questions. Is the item subject to the EAR? And how do you know? You just don't just come up with, oh, we're well below 25%. You want to have that documented and taken inventory so that you get to the correct percentage. So in terms of practical considerations, with Huawei, well, with anyone else really, it's important to get certifications, end-use certifications, either from the end user, so here Huawei, or from the intermediary at least. Again, knowing the classification, knowing the U.S. content, having robust export control provisions, looking into third-party involvement. That's just a classic issue. Intermediaries are typically the ones that get companies in trouble in terms of sanctions violations, export control violations. Understanding the business risk, right? We've seen Huawei taking a pretty aggressive approach, whether, for example, comparing companies and saying, say, to a smaller manufacturer, software company, hey, competitor XYZ is shipping to us, and oftentimes that's not even true. And then certainly increased scrutiny from U.S. regulators, not just with exports to Huawei, but just across the board. So quickly, just scenarios. What does this mean from a practical perspective? And again, don't just think about Huawei, but for anyone else, to a U.S. company that exports sensors to Huawei or to company XYZ out of Boston, isn't that item subject to the EAR? So do the U.S. dual-use regulations apply? Yes, absolutely, right? It's coming out of Boston, it's subject to the EAR. Now I've got a Chinese subsidiary that intends to export Chinese-made, right? So foreign, from a U.S. perspective, a foreign sensor to Huawei or to anyone else in China. Now here, this is where I have to bring in the de minimis threshold, 25%, or zero if we have a look-through item. And again, taking inventory and keeping a good de minimis chart. Software, we could talk about software for a long time. Here we have U.S.-based software company X exporting software to Huawei. If it's from the U.S. origin, and the analysis stops there. If it's stored on a U.S. server, right, that's an export out of the U.S. It will be foreign, be subject to the EAR. Now, it gets more interesting with encryption. So the takeaway with encryption, just for everyone to understand, given that most of encryption, like even very good encryption, say AES-256 standards or an OpenSSL, which software developers that we work with tell me that it's strong encryption that's publicly available. So what does that mean? My value will be zero. Now here the key takeaways, you always have to remember for encryption, you can't just use the de minimis threshold and say, hey, it's zero, I'm done in terms of the value. There are additional rules that apply notification requirements to be eligible to use the de minimis rule. And then at the end here, we have German software that does not include any U.S. software or source code, but it uses encryption standards, for example, from Oracle. As they've been published, they actually fall under an exception. So again, the key takeaway here is that one needs to understand the concept of something being subject to the EAR and whether the U.S. controls apply. Here we're just taking briefly stock of recent OFAC enforcement actions. I want to focus your attention to the third case here, Packard. Packard is interesting. So here we have basically a U.S. company's nightmare where an item was exported to Europe. It ends up in Iran. In the first situation, there were red flags. I can understand OFAC coming in. The European subsidiary received purchase orders and from Iran and told the U.S. company, well, these are their specifications, and the U.S. company said, we can't ship to Iran, and you can't do that either. And then the same day, the company internally then issued purchase orders for the U.S. company saying that their exports to Russia, but at the end of the day, were exactly the same specifications and the same delivery point, right? So, of course, that's bad. That should have been an immediate red flag. But interestingly, what OFAC also faulted here was that later, a dealer, European dealer that worked with the German subsidiary and exported to Iran, had obviously knowledge. No one else at the company, though, knew, only the dealer, and that knowledge was imputed. So, that's an important takeaway, because that is certainly something that is in the mind of many exporters and re-exporters in terms of liability with export to embargo destinations. Another case that is very important is Applichem. So for situations where companies are being acquired, this is a case that is really instructive. There are a number of those. So OFAC, raised the issue of successor liability, right? I'm buying a company, I step into the shoes, and I basically get the whole enchilada in terms of sanctions violations. Applichem is instructive because here, OFAC really walks us nicely through their analysis and what they did not like. So in Applichem, the company was going to get bought by a U.S. company. Prior to closing, the U.S. folks said, well, we know you exported to Cuba, you can't do that. A few weeks after closing, the U.S. company told Applichem, here are all our sanctions, compliance materials, read them, you cannot export to Cuba. They did export to Cuba. Then they received a written warning from the U.S. company, you can't do that, and so on. There was a voluntary disclosure, and the first time OFAC just issued a cautionary letter. Then, though, a couple of years later, there was a whistleblower saying, hey, these guys are still exporting to Cuba. And OFAC issued a very high penalty, considering that the value of the items was $3 million. So this is above that. And that the U.S. company, voluntarily disclosed and tried to mend things and train people and do everything they could. But nonetheless, what OFAC didn't like was that there was a written scheme from Applichem and that basically the U.S. company should have known. And interestingly enough, someone with an Applichem in Germany had told the Spanish intermediate parent, but as you probably know, Spain has a lot of historic ties with Cuba, lots of exports going there. So no surprise that the Spanish manager there did not take this seriously, so that was another issue. But again, the takeaway here is in terms of mergers and acquisitions and also private equity deals, to be cognizant of successor liability. There's been a number of cases, but again, the Applichem case is a very instructive one. And then lastly, right, the fourth eyelash kit. This is the last one. I like this case just because, it just shows in terms of embargo programs, really who cares about the eyelash kits in terms of, there's so many other issues that we should be tackling also in terms of national security, but it just shows that everything matters for the broad embargoes, and especially here in terms of suppliers, right? Monitoring the supply chain. OFAC describes very nicely what they're looking for, right? So lack of supply chain audits is an issue. And when we work with companies, it just comes up over and over again that there's not enough sanctions compliance on the supply side, right? So importing into the U.S. and making sure that there are no sanctions violations. I'm going to stop here. So this is the last presentation. And with that, back to Nicole in terms of questions.
Thank you all for your presentations today. As Alexandra said, we will open it up to any questions. You can use the question module on your screen to submit those. I'll give everyone just a minute. Okay. This question is coming in, and it is for Doreen. What technologies have been identified as emerging and foundational technologies? And emerging and foundational technologies is in quotations.
Well, right. What we know so far that the government has said that they're going to include or biotechnology, positioning, navigation and timing technology, microprocessor technology, excuse me, artificial intelligence, machine learning, quantum computing, 3D printing, advanced computing, logistics technology, robotics, brain-computer interfaces, hypersonics, advanced material, and advanced surveillance technology. But these are the sectors that have been identified, and the regulations have not come out giving us any more guidance on that.
Thank you. Jonathan, I'm assuming this is for you since it references Canada. How do you think the Canadian government would react if the U.S. seeks changes to the USMCA as currently drafted?
Yeah, certainly. So I think it would very much depend on what the changes are. A lot of the changes that I've heard about coming from the U.S. Congress, particularly from the Democrats, relate to things that I think Canada would be sympathetic to: environmental concerns, labor standards, those kinds of things. I think there'd be some initial reluctance, given that Canada kind of considers that the deal has been signed and they want to move forward with it. But if push came to shove, I think a lot of the changes that are being discussed are something that Canada could be open to.
Great. Okay, we have another question. If goods are manufactured in China and then shipped to another country, such as Vietnam or Malaysia, for final assembly and packaging before being shipped to the U.S., will that be enough to avoid the Section 301 tariffs against China?
This is Alan. I'll respond to that. Short answer, probably not. Unless the activities that are done in the third country are going to be sufficient to change the country of origin of the goods, and that's in the eyes of the U.S. Customs, then Customs is likely to consider them to still be Chinese origin goods, regardless of where they're imported from. And, also just as an aside, final assembly and packaging are rarely sufficient, really under anybody's country of origin rules to transform the goods, regardless of whether you're seeking an HTS classification change or an actual, country of origin change. So again, probably not going to have to do more to substantiate a country of origin change.
And we have, it looks like, one more question. Can you provide a brief update on the Venezuela sanctions, particularly as it relates to exports of medical devices to government?
Okay, so we've seen an increased sanctions against Venezuela. Venezuela is certainly not fully embargoed, but it's a very different scenario, say, from Iran or North Korea. But nonetheless, many more folks being sanctioned. And in particular, this summer, the Venezuelan government was fully sanctioned. So the issue with medical products, yes, is that, of course, the majority of the hospitals are government-owned. But there is a new general license 4C that companies can use. From a practical perspective, there it's important to claim that exemption when the items leave the U.S.
Great. Well, it doesn't look like we have any other questions right now, and we're right on time. So with that, I want to thank all of our presenters for all their knowledge and time today. Thank you to everyone who logged in and listened. If you have any questions, please feel free to reach out to any of the presenters. This now concludes the webinar. Thank you and have a wonderful rest of your week. Bye-bye.